A journey long through paths unknown.
Welcome back to the Prima.Law podcast, and today our topic is the H-1B visa. So these are visas for individuals who are in a specialty occupation. Now, it's been in the news a lot recently because, quite famously, if you want to apply for an H-1B visa now, in order to enter the United States, you have to pay an additional $100,000 fee. Okay, so that's ridiculous. It's going to really disincentivize many companies from petitioning for any H-1B workers, because for $100,000, if you were to just give that to the prospective employee anyway, they could probably buy a couple houses in their home country. Okay, it's an enormous amount of money for a visa fee. In fact, there's no visa fees that come even close to that. Even when you include the attorney's fees, even in the most dramatic situations, I'm not aware of an immigration court case, where someone paid $100,000 in order to just fight the case. So that's the topic of today. I figured what a good time for us to get familiar with the H-1B visa, when it can be used, what the requirements are, and just in case this $100,000 fee goes away, maybe at some point people will be able to apply for it again. Now, I'm attorney James Betzold. I'm a practicing immigration attorney, and we are brought to you today by Prima.Law. So Prima.Law is immigration case management software. It has all the tools you need to run an efficient immigration practice. So whether you're a paralegal or an immigration attorney, we have all the checklists, all the case templates, all the things that you're going to need, including invoicing, billing, payments, these e-payments, right? A client portal, checklists that you can send to your client, and they can upload documents directly to their client portal. These documents go right into the system. Then you can put it all together with package assembly, or even use our new smooth e-filing feature. Use tools that we've included, we've used AI to review your cases before you submit them to immigration to make sure that you haven't missed a thing. All right, find a free 15-day trial at www.prima.law. Let's begin the show.
So if you're a skilled professional thinking about working in the U.S., or maybe you're an employer trying to navigate hiring international talent, this visa category has seen some, pretty complicated changes lately.
It really has. Significant ones.
Our mission today is simple. Give you a really clear picture of these updates, help you navigate it all with, a bit more confidence.
Absolutely. And it's a landscape that, frankly, needs attention. The H-1B, it isn't static. It's constantly being shaped by new rules, clarifications, sometimes even court cases.
Right.
So for this deep dive, we've gathered the latest info government regs effective now and into 2025, official USCIS guidance, some key legal settlements too. The idea is to pull it all together, give you that actionable knowledge, the why behind the what, without getting totally lost in the weeds.
Exactly. Think of this as your shortcut to being genuinely informed. We'll try to uncover some maybe surprising facts and just get to the core of what you need to know, from applying to the long-term picture.
Sounds good.
Okay, let's dive in. Let's start right at the beginning. What is an H-1B fundamentally, and what's this specialty occupation thing USCIS looks at so closely?
Okay, so at its heart, the H-1B is a non-immigrant visa. It's for temporary professional workers, usually in what they call specialty occupations,
Right.
or sometimes, interestingly, distinguished fashion models. But the real focus, the scrutiny from USCIS, it's all about that specialty occupation.
Could define that for us.
It means the job itself has to require applying, theoretical and practical knowledge that's highly specialized. And usually the minimum entry requirement is a bachelor's degree or its U.S. equivalent in a specific field.
Things like architecture, engineering.
Exactly. Architecture, engineering, medicine, certain business specialties, law, the arts. Fields like that. It's not just about having a degree. It's about that specific degree level and field being essential to actually do the job.
Okay, and this is where we hit a really critical recent change, right?
Yeah.
About the degree needing to be directly related.
Absolutely. This is a big one. Starting January 2025, new DHS regulations, they spell it out pretty clearly.
How so?
Your degree must be in a field directly related to the duties of the job. So a general degree, say like liberal arts, without a clear specialization, that might not be enough on its own anymore.
So what does that mean for common roles? I'm thinking like a market research analyst.
Yeah.
People might have degrees in stats, marketing, maybe business.
Right. That's a great example. And it raises a really important question. Does this stricter rule make it harder for those kinds of jobs?
Yeah.
Well, thankfully, a 2024 final rule actually brought some much-needed clarity here. It's kind of a relief, actually.
Okay, good. What did it say?
It clarified that a job can still qualify even if it accepts a range of different degree fields. The key is that each of those acceptable fields must be directly related to the job's functions. There has to be what USCIS calls a logical nexus.
A logical nexus.
Okay, so for that market research analyst, accepting degrees in statistics or marketing or business analytics, that's fine, as long as each of those specific fields genuinely equips someone for the core tasks of the job.
Got it. So it's not just about the job title, but the actual substance of the required education.
Precisely. And this clarification, it partly came out of a legal settlement.
Yeah.
Medkudu Inc. v. USCIS. That case helped push back on USCIS just denying petitions because the official job description handbook, the OOH, listed multiple majors.
Oh, okay.
Now, officers are supposed to look at the common body of knowledge needed for the role. It feels much more practical.
That makes sense. But what if your degree isn't from the U.S., or maybe you don't have a traditional bachelor's degree, but years of experience?
Good questions. For foreign degrees, you'll need an evaluation. An advisory evaluation from a qualified source. It basically documents the U.S. equivalency of your degree, focusing just on the formal education part.
And experience instead of a degree.
Yes, that's possible too. The rule of thumb is generally 3 years of progressive work experience equals 1 year of full-time university study for a bachelor's.
So 12 years of experience could potentially equal a bachelor's.
Exactly. 12 years of relevant progressive experience. And for a master's equivalent, you typically need a relevant bachelor's plus 5 years of experience in that specialty.
Okay. And briefly, what about professional licenses, like for doctors or engineers?
Right. If the job normally requires a state license to practice, then yes, you generally need that full unrestricted license.
Always up front.
Usually, yes. But there are exceptions for things like temporary licenses or if you can practice under supervision as allowed by the state. Doctors doing patient care have extra hurdles, though.
Such as?
Things like passing specific exams, FLEX or USMLE, and an English test from ECFMG, unless they went to med school in the US or Canada. It's about meeting those specific professional standards.
Got it. So, okay, once you figure out who qualifies, the next massive challenge, maybe the most stressful part for many, is just getting selected. Let's talk about the annual cap in the lottery.
Yeah.
Because the rules there have really been turned upside down.
They absolutely have. The whole lottery system has changed dramatically over the years. Remember, before 2020, employers had to send in these huge, expensive application packages just to enter.
Oh, yeah, I remember that.
Then they switched to the electronic registration system, which was simpler. But the really big shift, the one affecting everyone now, hit for the FY 2025 cap season. That started March 2024.
And what was that shift?
USCIS started selecting registrations on a per-beneficiary basis.
Per beneficiary, explain that.
It means they select based on the individual person, the foreign national, not based on how many registrations were submitted for that person.
Ah, so one person, one chance in the lottery, regardless of how many companies want to sponsor them.
Exactly. One person, one entry into the lottery pool. It fundamentally levels the playing field.
Wow. What was the reasoning behind that?
It was a direct move to crack down on fraud. There were serious issues with multiple companies, sometimes even related ones, submitting registrations for the same person just to boost their odds unfairly.
Right, gaming the system.
Precisely. This change effectively puts an end to that for individuals. It's a huge anti-fraud measure.
How do they enforce it?
Well, employers now have to provide the beneficiary's passport information when they register, and they have to attest, basically swear, that the job offer is legitimate.
And if they find fraud?
If USCIS finds evidence of fraudulent or deliberately duplicative registrations, say, shell companies trying to game the system, those registrations get tossed out. Any resulting petition would be denied or even revoked later.
Did it work? Did the numbers change?
Oh, yeah. Immediately. Total registrations dropped almost 39% between FY 2024 and FY 2025. But crucially, the number of unique individuals, unique beneficiaries, that stayed pretty stable, around 442,000.
So fewer registrations overall, but roughly the same number of people applying.
Exactly, and the average number of registrations submitted per person, it fell from 1.7 down to just 1.06.
Wow.
Those numbers really show the anti-fraud measures are having a real impact, making the lottery fairer.
Okay, so that door is closed. But are there still ways to bypass the cap entirely? For certain employers, maybe?
Yes, definitely. There are what we call cap-exempt employers. Think universities, nonprofit research organizations, government research bodies, and also nonprofits that are formally affiliated with universities. And interestingly, the 2024 rules actually broadened this a bit.
How so?
Now, for an institution to qualify, research or education just needs to be one of its fundamental missions. It doesn't have to be the primary one.
Okay, that's a subtle but important shift.
It is. And here's another big update, very relevant today. Work performed at a cap-exempt place now explicitly includes remote work.
Really? Even if you work from home for, say, a university?
Yes, provided the work you're doing genuinely furthers a fundamental purpose of that university, and you, the H-1B worker, spend at least half your time on those specific duties, even if you're technically employed by a third-party contractor placing you there.
That's huge, especially with how much remote work happens now.
Yeah.
What about students on F1 visas waiting for their H-1B? The cap gap.
Right, the cap gap. Another helpful change in the 2024 rule, it extended the work authorization for F1 students caught in that gap.
What's the extension now?
Their work permission can now run through April 1st of the following year. That potentially gives them an extra 6 months of work authorization while they wait for their H-1B to kick in.
That must relieve a lot of stress for students.
Absolutely. It reduces the risk of having a gap in employment authorization, which was a major worry.
Okay, let's shift gears. We've talked about the applicant side. What about the employer? Sponsoring an H-1B isn't just paperwork. There are real responsibilities, costs.
Oh, definitely. And the Department of Labor, the DOL, watches this very closely. It all starts with something called the Labor Condition Application, or LCA.
The LCA.
Right. Employers have to get an LCA certified by the DOL before they can even file the main H-1B petition with USCIS.
And what does the LCA involve? What are employers promising?
Several key things. They attest they'll pay the required wage. That means the higher of either the local prevailing wage for that job or the actual wage they pay their other workers with similar experience and qualifications.
Okay, wage is key. What else?
They also attest that hiring the H-1B worker won't negatively affect the working conditions of U.S. workers, that there's no strike or lockout happening, and that they've notified their current employees about the LCA filing.
That prevailing wage part sounds complicated. How is that determined? Those SOC codes?
It can be tricky, yes. The prevailing wage comes from the DOL's online wage library. It uses standard occupational classification, or SOC, codes to categorize jobs and then assigns wage levels, usually level I through IV.
I is entry, IV is more managerial.
Generally, yes. Entry level up to highly complex or managerial roles. The challenge sometimes is that these codes don't always keep up perfectly with new or niche roles, especially in tech startups. Think product manager finding the exact fit isn't always straightforward.
And I remember there used to be issues with level I wages being challenged.
Yes, under the previous administration, there was a period where level I wage filings were heavily scrutinized, arguing they couldn't possibly be specialty occupations. That specific issue seems less common now, but ensuring the wage level matches the job's complexity is still critical.
Beyond wages, what about the actual filing fees? Who pays for those?
The employer pays. There are significant costs. The base filing fee went up in April 2024. It's $780 for most employers now, $460 for smaller employers and nonprofits.
Okay.
Then there's the electronic registration fee for the lottery that jumped massively from $10 to $215 for the FY 2026 cap season. Plus, there's usually an ACWIA fee, a fraud prevention fee, maybe a large employer fee depending on size.
And premium processing, if you want it faster.
That's another $2,500 paid by the employer usually if they want expedited processing. And here's the crucial part. DOL rules are very strict that employers cannot make the worker pay for these specific employer business expense fees if doing so would dip their effective wage below the required LCA wage.
Got it. So the employer bears those costs. What about the public access file? The PAF? Sounds like something employers need to keep track of.
Yes, the PAF. It's basically the employer's compliance file for each H-1B worker. They have to create it within 1 business day of filing the LCA.
What goes in it?
A copy of the certified LCA itself, documents showing how they figured out the prevailing and actual wages, proof the worker got a copy of the LCA, notice of the posting, a summary of benefits offered, documentation of any major corporate changes. It's pretty comprehensive.
And who gets to see this file?
It has to be available to any interested or aggrieved party. That usually means someone with a legitimate reason to inquire, like a U.S. worker who thinks they might have been adversely affected, or the DOL itself.
How long do they keep it?
They have to keep it for 1 year after the H-1B employment ends, or 1 year after the LCA expires or is withdrawn, whichever is later.
Okay. Now, a really core H-1B concept. The employer-employee relationship. This used to be a big point of contention, right? Especially with that Neufeld memo.
Oh, absolutely. The Neufeld memo, for years, imposed this really strict multi-factor test to prove an employer-employee relationship existed. It made things particularly tough for consulting companies or workers placed at third-party client sites.
But that changed.
Yes, thankfully, it was rescinded in 2020. Now, the standard is back to the basic regulatory definition.
Which is?
Does the petitioner, the employer, have the right to hire, pay, fire, supervise, or otherwise control the H-1B worker's employment? It's focused on those fundamental elements of control, not a rigid checklist.
That sounds more straightforward. What about founders, people starting their own companies? Can they use an H-1B? That seems like the ultimate control issue.
Exactly. It blurs the lines, doesn't it? Historically, it was extremely difficult for a founder who owned a majority stake to get an H-1B through their own company.
What?
But another significant change in the 2024 rules specifically addresses founder-owned startups. It is now possible for a beneficiary who has a controlling interest, say over 50% ownership, to be sponsored for an H-1B by their own company.
How does that work with the control requirement?
The key is demonstrating that some other entity or structure has the actual right to control the founder's employment, like an independent board of directors.
Ah, okay.
And critically, the founder must primarily be performing specialty occupation duties. More than half their time must be spent on those H-1B eligible tasks, not just general management.
So if Sarah starts a tech company, her board needs to supervise her, even as CEO. And her main job needs to be, say, software engineering.
That's the idea. And USCIS is watching these closely. Initial approvals for these founder cases are typically granted for only 18 months, not the usual 3 years, just to monitor the arrangement.
Interesting. Okay, so someone gets the H-1B, they're working. What's life like on the visa? What are the limits, the flexibilities, and what about bringing family?
Right. So the initial H-1B is usually granted for up to 3 years. You can extend it, but generally there's a total limit of 6 years in H-1B status.
Only 6 years. What if you're trying to get a green card?
Ah, good point. There are important exceptions. You can extend beyond 6 years if you have a green card application sufficiently far along in the process.
How did that work?
Usually it means your I-140 immigrant petition has been approved, or you qualify under certain AC-21 provisions, which allow extensions while dealing with green card backlogs. So that 6-year clock isn't always a hard stop.
Does time spent on other visas count towards the 6 years? Like an L1?
Yes, time spent in L1 status does count against the H-1B 6-year limit, but time spent as a dependent, like H-4 or L2, does not count.
Okay. And what if your job ends unexpectedly? Are there grace periods?
Yes, there are a couple of important ones. First, there's always a standard 10-day grace period before your H-1B starts and after it ends. You can't work during those times, but you can be legally present.
And if you get laid off?
That's where the 60-day grace period comes in. This was established back in 2017. It gives H-1B workers and their dependents, too, up to 60 consecutive days after their job ends to find a new sponsoring employer, change to a different visa status, or prepare to depart the U.S.
60 days, is that always available?
It's available once per authorized validity period. So if you get an extension, you could potentially use it again later if needed.
Any other extensions? What if your current status expires while an extension is pending?
Yes, that's the 240-day rule. If your employer files an H-1B extension petition before your current I-94 status expires, your work authorization is automatically extended for up to 240 days while USCIS decides on the extension. That prevents a gap in work permission.
Okay, let's unpack job changes. If you're on an H-1B and get a job offer from a different company, do you have to wait months for the new petition to be approved before you can start?
No, thankfully. This is a huge benefit called H-1B portability.
Portability, how does it work?
You can actually start the new job with the new employer as soon as they properly file a non-frivolous H-1B petition for you. You don't need to wait for the approval notice.
Seriously, just file and start.
Pretty much. Your work authorization continues with the new employer while the petition is pending until it's ultimately adjudicated.
What are the conditions?
You need to have been lawfully admitted to the U.S. The new petition has to be filed timely and be non-frivolous, meaning not groundless. And you can't have worked without authorization before.
Can you use portability during those grace periods we talked about?
Yes, you can. Both the 10-day and the 60-day grace periods allow for portability filings.
That offers a lot of flexibility for career move. Is there any catch? What about moving from cap exempt to cap subject?
Ah, yes. That's the main catch. If you're currently working for a cap-exempt employer, like a university, and you want to move to a regular cap-subject company, you do have to go through the H-1B lottery again because you haven't been counted against the annual cap before.
Right, but what if you keep the university job and add a part-time job at a company?
That's possible. It's called concurrent employment. You can maintain your primary cap-exempt job and add a cap-subject job without needing a new lottery selection for the second job, as long as you keep the first one.
Okay. And what if things go the other way? What if an employer terminates an H-1B worker early? Are there specific employer liabilities?
Yes, there are. If an employer dismisses an H-1B worker before their authorized period of stay ends, the employer is legally obligated to pay for the reasonable costs of return transportation for the worker back to their last country of foreign residence.
Return transportation. Anything else?
They can also be liable for back wages if they terminate the employee, but fail to formally notify USCIS that the employment relationship has ended and that the H-1B petition should be withdrawn.
Good to know. Finally, let's talk about family, spouses, and children. What status do they get and can they work?
Spouses and unmarried children under 21 can accompany the H-1B worker in H-4 dependent status.
Can H-4 spouses work? I know this has been a hot topic.
Yes, certain H-4 spouses can apply for an employment authorization document, an EAD, but there are conditions.
What are they?
Generally, the H-1B spouse must either have an approved I-140 immigrant petition, that's the main green card petition filed by the employer,
Right.
or they must have received certain extensions of their H-1B status beyond the usual 6-year limit under the AC-21 rules, usually because they're waiting due to green card backlogs.
Okay. And weren't there huge delays in getting those H-4 EADs processed?
Yes, absolutely. It caused enormous problems for families. But there was a major development here, too.
Yeah.
A legal settlement, Edicuni v. Mayorkas in January 2023, addressed this directly.
And the outcome?
USCIS agreed to bundle the processing. They'll now adjudicate H-4 status applications and H-4 EAD applications concurrently with the main H-1B petition, as long as they're all filed together.
Concurrent processing. That's big.
Huge. And they also agreed to allow H-4 and L-2 dependent forms to be included in premium processing requests along with the principal's petition.
So faster decisions for the whole family, potentially.
That's the idea. Plus, they codified automatic extensions for H-4 EADs under certain conditions. If you file for renewal before it expires, you can get up to 180 days extra work authorization, or until your I-94 expires, whichever is sooner. It provides much-needed continuity.
That settlement sounds like it made a real difference for many families.
It really did address some critical bottlenecks and uncertainties.
Okay, looking broader now, it feels like H-1B policy is always shifting, often depending on who's in charge politically. We saw those big swings in denial rates a few years back.
Absolutely. The political climate is a major influence. Denial rates for initial H-1B jobs shot up significantly during the Trump administration, reaching almost 29% in FY 2020.
Wow.
But then, after some policies were challenged in court, those rates dropped dramatically down to just 2% by FY 2022. It shows how administrative priorities and legal challenges really shape the day-to-day reality of the program.
And it's still contentious, right? The tension between tech industry needs and immigration restriction arguments.
Always. It remains a hot subject, as you said. You constantly see that push and pull between, say, Silicon Valley needing skilled workers and groups concerned about the impact on U.S. jobs. It creates uncertainty.
Definitely. Amidst all that, one feature of the H-1B that seems consistently valuable is its dual intent nature. Can you break that down? Why is it important?
Yes, dual intent is a key strategic advantage of the H-1B. It's quite unique. It means H-1B holders are legally allowed to have two intents at the same time. The short-term intent to work temporarily in the U.S. on the H-1B, and the long-term intent to immigrate permanently by pursuing a green card.
So, applying for a green card doesn't jeopardize your H-1B status.
Exactly. Unlike some other visa categories, starting the green card process isn't seen as conflicting with your temporary H-1B status. You can pursue both paths simultaneously.
Any other benefits to that?
Yes, a big one for travel. If you have a pending green card application, adjustment of status, you can generally still travel internationally using your valid H-1B visa to re-enter the U.S. You don't necessarily need a separate advanced parole travel document, which can sometimes be cumbersome to get or use. It offers much more flexibility and certainty for travel.
That's a really practical benefit. Now, speaking of convenience, there was another recent development that got a lot of H-1B holders pretty excited, right? Something about renewal.
Yes. What stands out there is the H-1B Visa Revalidation Pilot Program. This ran earlier in 2024, from January to April.
Revalidation, meaning renewing the visa stamp.
Exactly. For the first time since way back in 2004, certain H-1B workers were able to renew their visa stamps right here within the United States.
Without having to travel back home for a consulate appointment.
Precisely. No need to leave the U.S., book an embassy appointment, deal with potential delays. It was a pilot program, limited scope, processing about 20,000 renewals.
Any word if it will continue or expand?
The government is assessing it. If it's deemed successful, the hope is that it might be expanded, possibly even to other visa categories eventually. It represents a potentially huge step in modernizing and simplifying the process, removing a major headache for many workers.
Definitely something to watch.
Yeah.
Wow, okay.
Oh, yeah.
We've covered a ton of ground today. It's clear this is a really dynamic area.
It really is.
Just to quickly recap the highlights, we dug into what specialty occupation really means, especially with those new 2024 and 2025 rules about directly related degrees and the Madkudu settlement's impact.
Right, the move towards the common body of knowledge.
We talked about the huge shift in the lottery, now beneficiary-centric, one person, one chance, as a major anti-fraud tool.
And the impact on registration numbers showed it's working.
We covered the broadened cap exemptions, crucially including remote work now, and the extended cap gap relief for F1 students.
Important practical changes.
Then we looked at the employer side. The detailed LCA requirements, wage rules, who pays the fees, the public access file, and even how founders can now potentially sponsor themselves under specific conditions.
Lots of compliance points there for employer.
And for workers.
Yeah.
That vital H-1B portability letting you change jobs faster, the 60-day grace period, extensions beyond 6 years tied to green cards, the expanded H-4 work authorization thanks to the Itakuni settlement, and that exciting potential return of stateside visa renewals.
It's a lot of moving parts, and the key takeaway really is that this landscape is constantly evolving. Policy shifts happen due to lawsuits, new regulations, changing administration priorities. So staying informed is critical. Whether you're an employer trying to hire or an individual planning your career here, it demands adaptability.
Absolutely.
And that is going to wrap up our presentation for today. Now, you may say, hey, I don't practice employment immigration. I just do family, or I just do removal. Why do I need to know about an H-1B visa? Well, you never know who's going to come across your path. You never know when you're going to need that information. Sometimes you may have a client in removal proceedings who could apply for an H-1B visa as well, because maybe they have a petitioner who can petition for them and they have some specialty knowledge. Okay, so I always like to say, when people ask about the practice of immigration law, I like to say it's a unique type of law because it can touch on so many other areas of law. It may touch on family law, criminal defense. It may touch on property law. It may touch on estate planning law. And there's always, especially recently, opportunity for federal litigation. Right? So if you have that dream of being the attorney who goes to federal court to win your big case, maybe go all the way to the Supreme Court, immigration can provide an avenue for that. And it's very often that's happening recently. So again, I'll remind you to just to subscribe so that you don't miss any of the new episodes that we are releasing. And again, we are brought to you by Prima.Law. So that's Prima.Law is the website. It's immigration case management software. Okay, it is enterprise software for running your immigration practice. Now, you may be a solo practitioner and it's going to save you hours of time. You may have a medium or small sized firm or a large firm, in which case it's going to save you many dozens or hundreds of hours per week. All right, find a free 15-day trial at Prima.Law.